So let's go into session one. So I would ask Justices Anderson, Huang, Oranje, my Dutch pronunciation must be terrible, and Justice Schaller to be with their cameras on. So this first session, and the main purpose of the first session, is to indeed discuss how the convention enables or enhances the operation of international commercial courts and to what extent. We have organized this session in 4 parts. There will be first a roundtable or a tour de table, better said, where each speaker will present their own court. We will then have 2 justices discussing some of the aspects of the jurisprudence of their courts, particularly instances in which they have declined jurisdiction or were challenged in their jurisdictional decisions. We will then have a more general commentary by Michael Huang on these aspects and others based on his experience from the Dubai International Financial Court perspective, from the time he was at the court. And then we will finalize with another tour de table where speakers will focus a little bit more on the recognition and enforcement of judgments from their courts. Just to clarify, that discussion will not focus, of course, on the Brussels regime nor in any intra-EU litigation. And the discussion will have the Choice of Court Convention as a reference point to the extent possible. So let's start this first tour de table. I would ask the speakers to introduce their court, to share any statistics that they may have, and also to describe eventual trends they see in relation to the instances in which they assume jurisdiction, and if it's based on exclusive, asymmetric, non-exclusive choice of court agreements or referrals from other courts. I would invite, and before giving the floor, I would invite all attendees to consult the bios, the information about our speakers, which is posted on the website. That would save us some time introducing our speakers. Therefore, let's start with the tour de table. Justice Anderson, may I ask you to be the first to take the floor?
Thank you, Chairman. I'm very happy to be the first to take the floor. And to say by way of introduction that I was very pleased to have heard from Professor Trevor Hartley at the start of the program. He, of course, would not recognize me at all, but I was one of his students in the Inns of Court School of Law program in the mid-1980s in England. And I thoroughly enjoyed his presentations then, and of course the one this morning. So thank you very much, Professor Hartley. I would also say that the Convention on Choice of Courts is something that is in its essence very familiar to us in the Caribbean, because in large part it follows many of the important common law rules on jurisdiction, which we still adhere to in this part of the world. I'm a member of the Caribbean Court of Justice, and the CCJ is the highest judicial body in the Caribbean. We have 2 jurisdictions, one of which is the original jurisdiction in which we hear trade disputes between member states of the community. And in that jurisdiction, this question of the choice of course is not terribly important. That jurisdiction is concerned with the resolution of interstate trade disputes. The second jurisdiction, however, is very relevant. And in the second jurisdiction, we hear final appeals from national courts of the countries that have subscribed to our appellate jurisdiction. And thus far, there are 4 such courts. There is Barbados, there is Belize, there is Guyana, and there is Dominica. So strictly speaking, when I speak about the approach to jurisdiction, in the background of that convention, I'm strictly speaking about the situation in those 4 countries. However, I think it is fair to say that we still follow the common law rules for the most part. And therefore, what I say is also applicable to all of the other 13 states in the Caribbean that have followed the common law tradition. So the first point I wish to make is that in relation to the recognition of jurisdiction of foreign courts, the CCJ, and by extension the other courts in the Caribbean, tends to adopt basically a discretionary approach as to whether jurisdiction will be recognized or not. That is a fundamental basis on which jurisdiction is adjudicated. The court has a discretion, so that even if parties have chosen their court for litigation, the Caribbean courts can still say, sometimes in exceptional circumstances, that that choice will not be respected. Now, the point, however, is that the basic motivating principle is that the choice by the parties of a foreign court will, generally speaking, be respected. And that is grounded in very important jurisprudential, almost philosophical considerations, which are basically that the parties have chosen through their contracts freely entered into where they wish to litigate their dispute. And if the parties have chosen in this way where they will litigate their disputes, then the Caribbean courts are very, very anxious, in fact, to hold the parties to their bargain so that the case is litigated in the foreign country that they have chosen. We do not have very many idiosyncratic legislation on the point. And therefore, as I said, these rules are predominantly the rules of the common law. Now, there has been no cases that is known to me where parties, foreign parties, have chosen Caribbean courts as the forum for litigation, and we have stayed those proceedings in favor of litigation somewhere else. Caribbean courts always abide by, comply with the choice of Caribbean courts as the place for litigation. And the opposite is also true, that where the parties have chosen a foreign court to litigate their disputes, Caribbean courts will do all that they can to ensure that the dispute is litigated in those foreign courts. So if necessary, Caribbean courts will institute an anti-suit injunction or an injunction preventing litigation taking place in the Caribbean so as to force the parties to litigate in their chosen forum. And in fact, if the parties chose to litigate in a forum other than their chosen forum and they come to the CCJ or another Caribbean court, again, the approach is to stay those proceedings in these other courts so that the proceedings can take place in the chosen forum. And there are several cases, which I won't bore you with, I have time, very limited time, but there's a very important case that came to the CCJ in 2013. A massive case from Belize, British Caribbean Bank against Attorney General of Belize, where the local courts, the Court of Appeal in Belize, had issued an injunction against the parties litigating, in this case, arbitration in London. And the parties came to us at the CCJ, and we discharged the injunction so as to allow the litigation to go forward in London.
Thank you, Justice Anderson, and we'll have another round, and perhaps to keep us on track, if you don't mind, I would ask now Madame Schaller, Justice Schaller, from Paris, from across the ocean, to share with us the experience of the Paris Court, the International Commercial Chamber at the Paris Court of Appeal. Madame Schaller, could you share with us your experience?
Thank you very much, and thank you very much for this invitation. It's a great honor to discuss with all my honorable colleagues on this very interesting topic with respect to choice of court agreements. As you know, Paris has established an international commercial chamber in the Court of Appeal of Paris in 2018. And this court specializes in international commercial disputes and also international arbitration. The creation of this court was triggered by Brexit in a way, but it was not the only reason. It was promoted by an association called Paris Place de Droit, and our purpose, our intention is to be closer to international standards on the proceedings in this field and to cater the needs of the litigants in international disputes. That's why it was designed also to boost the choice of Paris as a forum for possible trade disputes. And I just want to make a very short description of this International Commercial Court before coming to statistics. The use of English is made possible before these chambers. The parties can plead, they can present documents, they can testify or call witnesses or experts in English without translation or interpretation, unless the parties wish so and they cover the costs for that. Only procedural documents must be in French. In front of this new chamber, in which I sit as a judge, the procedure is tailored to be adapted to the international commercial disputes, including states. States may also be represented in some important international arbitration disputes, for instance, but also commercial disputes. And we have cases already which are published on these specific topics. The procedure, we want to improve, of course, the efficiency of the proceedings. And I will show you now, maybe because I have only 5 minutes. I don't know if the technical support of
yes, we are ready to
show the slides, because I would like to invite you to go to the website of the ICCPCA. The website is bilingual, totally, French and English, and also Spanish and Chinese for some decisions. So that's something that I want to share with you, is the link to the website of our court, but you can find it later. The second thing I want to show very quickly is about statistics, because that's very important. Our statistics are accurate as of November 2021. And the number of cases since the creation of the court, I don't know if you can have it in these are slides, okay. So the first slide is about the number of cases. And you can see that the ICCPCA, just let me see if I had it at the same time. Anyway, we have rendered 153 judgments as of November 24th. And you can see on the screen that it covers decisions on jurisdiction for 27. We rendered 27 decisions on jurisdiction, and the rest is about international commercial disputes. International arbitral awards keeps us quite busy with 55 decisions, And decisions on setting aside internal arbitral awards is 12 decisions, and other decisions, which is very important, is 59 decisions. It's on breach of commercial contracts, international transport disputes, commercial agency, unfair competition, for example. The next slide is on the duration of proceedings, and you can see that we render decisions on jurisdiction in 5.7 months. So between 5 and 6 months, the decision on jurisdiction is rendered. For international arbitral disputes, it's longer because of the location of the parties abroad. So that's 23 months. And for average commercial disputes, it's 14 months between the time the case was brought into the dock and the decision. The next slide shows how many countries are litigating in the International Commercial Court in Paris. And you will see that litigants come from 73 different countries. Maybe I'm not on the right slide, sorry. This is the top 5 countries. Germany is with 28 litigants, 28 cases is the most represented. Italy with 21, Brazil with 19, the USA with 18, and Switzerland with 18. And all other litigants are in the big blue column. So I just wanted to say that Asia is represented with 18 countries, including China, South Korea, India, Japan, Singapore. Africa with 19 countries. We have cases coming from Algeria, Morocco, Tunisia, Senegal, Cameroon, and Mauritania. And the Americas in large, including the US, but also Brazil, Uruguay, and Venezuela. So these are the statistics I wanted to share with you. I also want to share with you a slide which was and maybe found back on our website. The Paris Place de Droit Association has drafted a template. We are not at all included in the drafting, and that's why I'm just mentioning as something that—
Madam Chair, may I take the floor as moderator? I think this could be interesting for our next round where we'll discuss jurisdiction, if you don't mind, to keep the pace.
Yes, good. I will keep this for later, because actually that's
very interesting.
Now I would go to the cases, so that's fine, and I'll speak later with the cases.
So that we go a little bit north now. We go to the Netherlands, and we hear also from the competition, from the Netherlands Commercial Court. Justice Oranje, please, you have the floor.
Hello. Hello meaning good morning, good afternoon, good night, whatever. So what's happening? I see all sorts of different pictures, but I assume that
you are on. I just ask everybody else to mute themselves, but you are on. We are hearing you very well. Thank you.
Thank you. I'll just go ahead. I think I just said hello. So my name is Duco Oranje. I'm the president of the Court of Appeal of the Netherlands Commercial Court. Maybe I could just briefly explain what we are. The Netherlands Commercial Court has been established as of the 1st of January 2019. It's not a new court. Instead, the NCC is merely a new chamber in the court of the Amsterdam District Court and a new chamber in the Amsterdam Court of Appeal. The most important feature of the Netherlands Commercial Court is that the litigation is entirely in English. The documents, the hearing, and the judgment are all in English. Parties may agree to litigate in accordance with the NCC rules either before or after the dispute has arisen. It has been stipulated by Dutch law enacting the NCC that the NCC must financially be self-supporting. So we are a chamber of the court, but we must be self-supporting. And in line with this, the court fees are somewhat higher than those of the regular Dutch courts. The court fees in first instance with the NCC are set at €50,000, and in the appeal, €20,000. But it's one fixed fee without regard to the interests involved. It's only possible to bring international matters to the NCC, and an international in a very broad sense. There's no financial threshold for the NCC, thus it will be possible to present class actions to the NCC as well. Although we must consider that if these are bundles of smaller cases, which they usually are, in respect of the convention, we have to consider that, of course, consumer cases are excluded. The law of process is Dutch procedural law, and a separate separate rules have been set up for the NCC, tailored to best global practices. The NCC rules are never to be in line with elements of litigation practice at the existing commercial courts and international arbitration institutes, such as the IBA rules on the taking of evidence in international commercial litigation. So this with us includes court reporters, video, audio recordings, teleconferencing, and video conferencing. The NCC court in first instance also has a chamber for provisional relief. And a separate English digital portal has been built for submitting documents and exhibits online. Everything, including the communication with the court, can be done through this portal online. The judges of the NCC are judges with extensive experience in international commercial matters and have command of English, legal English. And these judges are drawn from all the various courts in the Netherlands. Now, it is provided by Dutch law that an agreement to opt for the NCC must be made in writing and explicitly. Consequently, a choice for the NCC cannot merely be made by means of tacit consent in general terms and conditions. Another something peculiar, for parties to elect the Netherlands Commercial Court, it is necessary first, of course, to designate the Amsterdam District Court as the competent forum, the choice of forum for the Amsterdam Court. But in addition, as we are a chamber in the Amsterdam Court, they have to express their consensus for the proceedings to be conducted in English in accordance with the NCC rules. So you need to agree on two issues. The Amsterdam Court is the competent court, and within the Amsterdam Court, you agree the Netherlands Commercial Court, which then entails proceedings entirely in English and a somewhat higher court fee. The NCC is now in sort of a state to nascendi phase. We're dealing with 10 cases now, and these vary from the execution of pledges on shares, software contracts, shipping, implications of Corona on the performance of a contract. I think we actually were one of the, if not the first court in Europe that made a decision on the impact of Corona for your obligations on the agreements and construction. The parties we see are from Ireland, America, England, Switzerland, Russia, Philippines, and of course the Netherlands. Now, as to clauses, what we see mainly, and not just in the Netherlands Commercial Court chamber, but in the Amsterdam Court generally, is form agreements, but without mentioning that this is exclusive. So for instance, the Amsterdam Court, a party submit to the Amsterdam Court. And then this very often leads to discussions regarding if the defendants want to object, the applicable law relating to the clause, and of course the interpretation of the clause. But that is what we mainly have as main problem in regarding choice of courts. And we also now see, and I've not heard that before, that we see agreements with an arbitration, preliminary injunctive relief, or similar interim measures necessary to preserve rights pending the arbitration. So it's sort of a double clause, arbitration, but in addition, for preliminary relief and summary proceedings, the summary part of the NCC, which is the normal judiciary court. And then this, for me to end here, leads to two questions I have. I might be supposed to give answers, but sometimes one has just questions. The first being, does the convention now indeed provide for sufficient tools to tackle disputes regarding the applicable law and the interpretation as to whether the choice of forum is exclusive. Do we now have the tools in hands to answer all these questions? Well, maybe not all the questions, but many questions. And my second question, and that's maybe a bit out of self-interest as we see these clauses more often, can a clause providing for arbitration and for a judicial court in respect of summary relief be seen as exclusive regarding the summary relief? Now, that's for you to answer, I hope. Thank you very much for the moment.
Thank you very much, Justice Oranje. I hope you can answer those questions later on, but in any case, now I would give the floor to Michael, and in this quantic reality where we are at the same time in the morning and also in the evening in Singapore. Michael, can we hear from you in particular experiences from when you were at the DIFC? Please, you have the floor for 5 minutes, please.
Actually, I thought it would be more interesting to speak from the viewpoint of Singapore, where I'm actually based, because for this particular introductory session, I think the experience of Singapore is more interesting. Now, let me start. I'm going to have 5 points to make in the 5 minutes. The first point really is, what is the approach of common law countries to joining the Hague Convention? And Singapore and DIFC courts are both common law courts. Now, both our courts operate on the common law principle that all common law courts recognize foreign judgments coming from any other court in the world, whether they are common law or civil law courts. And that gives all court judgments recognition in approximately 50 countries and territories around the world. Of course, mostly territories of the British Commonwealth, but of course also including the US. And that's the first point, and that is the foundation for common law's approach to foreign judgments. So the second point I want to make is, from that viewpoint of a common law country and a common law state, like not the state, but the common law court like the DIFC courts, what are the advantages of joining the Hague Convention? And the big advantage for common law courts or common law countries is the prospect of having universal recognition of foreign judgments between common law courts and civil law courts. And the big prize in signing up the Hague Convention is the EU. And you take approximately 30 countries from there. And of the 30 countries, these are among the most important commercial countries in the world out of the civil law universe. It's a pity that there are no South American countries in that list, as far as I know. But, well, we'll settle for the time being for the EU. The third point I want to make. So certainly from Singapore's viewpoint, from very early days, we were very interested. And I can tell you that the vision was of Singapore when we first went in, we were hoping to gather together with us a mass of the more important Asia-Pacific common law countries to join up, not quite in a block, but sequentially. And we were hoping in particular that the major courts of the Asia-Pacific region, namely Australia, New Zealand, and even India might come along. Unfortunately, they haven't joined. I'm not privy to their thinking at the moment. So we are actually the only country from not just the Asia-Pacific region, but virtually the rest of Asia to have actually signed up for the Hague Convention, other than China. And I'll come to China in a minute. Now, the fourth point is, what about DIFC? Well, I personally, as Chief Justice, was very open to joining. But I soon found out that, unfortunately, the Hague Convention is only open to countries, not little pocket states like the DIFC. which only has 120 acres in territory. So therefore, we tried to persuade the UAE to join. No other Middle Eastern country was thinking of joining, and the UAE wasn't going to be the first. So we couldn't take that any further. I know that Hong Kong was also interested, but Hong Kong had exactly the same problem. Technically, they were part of China. China at that time wasn't interested in joining, so they could not join on their own. Now, my final point is, so you come down to the position of China, and China is the only other Asian country that has actually, I think they have signed or exceeded. No, I think they've signed, but they haven't ratified. I used to go to China a lot until the pandemic, and I know that this was discussed, and people were aware that the government had signed up for choice of court, because I used to do a lot of lecturing on how to enforce foreign judgments. And the Chinese legal profession had no idea about what was required for recognition of foreign judgments, even between civil law countries. And I asked a conference of very senior judges and legal officials, how many countries do you think recognize Chinese judgments? And everybody in the room looked around and thought about it. And one person put up his hand and said, 30. And what they were thinking of is the 30 treaties that China had signed. So then I had to explain to them the whole concept of the common law recognition. I said, you've got recognition in 50 countries and you don't know about it. And then I'll talk later about, memorandum of judgments, which is the method of having mutual understandings between countries pending signing of the Hague Convention. But I leave you with that. And later on, if you want to talk about the China International Commercial Court, maybe I can say a few words there as well, because the CICC cannot, by Chinese law, be constituted in the same way as my colleagues from Holland and France, or even Germany. I think I'll explain that in a future session.
That would be also very useful. Let's now go to our second point with Madame Chalet and Justice Oranje also to discuss, based on the jurisprudence on the court, the instances in which they have declined jurisdiction or were challenged in their jurisdictional decisions. And if we could have a little bit more detail, and also the point that was started by Madame Chalet, which is important in this regard. So I would give you also 5 minutes each to address this point, and then we will proceed probably to recognition and enforcement discussions afterwards. Madame Chalet.
Thank you. So maybe I can show the slide with the template of the clause conferring jurisdiction to the ICCPCA where I stopped, because this is interesting, and I think we have exactly the same situation in the Netherlands, is that the International Commercial Chamber is not a court by itself, it's a division of the court. So if lawyers want to include a clause choosing the French and maybe the Netherlands court, why not? They have to specify that they want to subject this clause to the jurisdiction of the International Chamber of the Paris Court of First Instance first, and all appeal from any decision of such court subject to the exclusive jurisdiction of the International Chamber of the Paris Court of Appeal. So this is a clause that was drafted by an independent association, and the court, of course, is not at all intervening in this. The other thing I wanted to show, but that's not based on our discussion now, is the protocol. You will be able to refer back to the protocol, so I'm done with the slides. My concern now is to just give in a few minutes, references to the case law that was that is quite important in our case, because you can find almost 30 cases on jurisdiction issues on our website, and all the decisions are in French, on the website. Some of them are translated into English fully, but all of them have a small resume, a small summary, which is in French, English, some of them in Chinese and in Spanish as well. So the 4 languages may be found on the website, and you can find summary of the cases on this website. I just want to draw your attention to some cases with respect to the trends that can be shown in, let's say, the last 10 years of the French decisions, which were, which have, of course, had an evolution in Europe, first of all, by applying the regulations, the EU regulations, but I won't talk about that. With respect to the French system, France now, I can say that the trend is to favor and to respect, of course, the choice of court agreements based on the agreement of the parties. So what is very important that we try to look in the case is, what is this agreement? Is it clear enough? Is it not null and void because of duress or economic duress, whatever? The efficiency of the clause is, of course, at stake, and the predictability also is very important. So I would like to just give a few examples of judgments that were rendered by the court. One of them concerned UK, but that was before Brexit. But I would say that we could use it today as well. It's a case rendered on July 4th, 2019. And this case was with Unilever and Anjou. The court, the French court, the commercial court, held that English courts had jurisdiction based on the clause that was in the contract. And that was very interesting because the claim was based on alleged abrupt termination of commercial relationship. And the claimant intended to have the clause rejected based on the fact that this distribution agreement was subject to policy arguments that could only be judged in the country where the contract took place. So this is very interesting to know that the French court held that the disputed clause was sufficiently precise to include actions for remedies of anti-competitive conduct by expressly referring to disputes which are of a contractual nature or not, such as tort claims for violation of law, a regulation, or other. I want to go back to the hibiscus apple cases, which you know, but it's interesting to know that our court has held the validity of the clause, even if the applicable law was considered as so-called public order and public policy law. So you will find on the website other cases, but it's interesting to know that Seoul's court was chosen in a clause. And our court held that this clause was valid, and we declined the French jurisdiction of the French court in favor of the Seoul, South Korean court. But I would say this would not help the convention of the 2005 convention, because it was the clause was inserted in a bill of lading. And but the court considered that this clause was valid, and our court said this goes back to the Korean court with Korean law applicable. Two other cases, just very quick: Georgia and Japan. We had in one case very interesting case from July 7th, 2020. You will find it on the website as well. Georgia's court was chosen in the clause. We could have validated the clause, because you will see in the decision that the clause was valid, was not null and void. But applying the law in this case, made the court decide to consider the clause valid but not applicable in the specific case, and you will have to go back to the I would say the matter and the decision to understand why the clause was not applied, but it was considered as valid and effective and could be applied if the conditions had been all considered together. And with Japan, it was a loan agreement between a French company and a Luxembourg company, including a clause conferring exclusive jurisdiction to the district court of Utsunomiya in Japan for any dispute arising from this contract. And I will refer back to the website. It's a case of February 26, 2021. The issue was whether a natural person resident in Belgium designated as guarantor in the contract was bound by this clause. And this was raised in front of our court. We considered, of course, that Brussels 1 was not applicable, and applying the French Article 48 of the Code of Civil Procedure, which is applicable in international matters, we held that even a natural person can be bound by the clause. And in that case, it was expressly stipulated in the contract, and the contract is valid. I'm not going further into the conditions of validity of the clause. You know them perfectly well. They are the conditions of validity of contracts, of course, but there are also other conditions that are in, you are all lawyers and judges, and I won't go further because I have run off my time.
Thank you, Justice Schaller. I'm really in trouble. It's counterintuitive to interrupt judges in my judicial tradition, so I hope you forgive me. Justice Oranian, I would give you the floor to add something to this point. You are on mute. Yes.
Can you hear me now? Casey, you have to unmute me. Anyway, thank you for unmuting me. As HCC, I was just saying, unfortunately, in the framework of this discussion, and as a court in Amsterdam, we have not yet seen much, if any, of the use of the convention at this moment. I guess that's mainly for two reasons. First, by means of the Brussels regulation 1 bis, no exequatur is needed for the enforcement. So a French judgment, you can send it to a Dutch bailiff who then executes, which is a very simple thing to do. Except, of course, if the defendant would raise all sorts of defenses based on public policy and so on. So, but that's the first reason. Secondly, the Dutch courts are prepared to allow the enforcement of a foreign judgment, even where no treaty or other international arrangement exists, by means of a new judgment in accordance with the original judgment, and in which the matter is not dealt with again. We just copy the foreign judgment, except in case of defenses regarding public policy or fair trial. So we are easily inclined to accept a foreign judgment, write it over again, put our signature if there's no strong reasons not to apply. But that's what we would call a full exequatur. Now, I think I'd like to mention the decision of the Netherlands Commercial Court from April 2020, which maybe shows a bit of problems we see. A letter of understanding was agreed upon and basically stated that the parties envisaged to enter into a transaction agreement, a share purchase agreement. The letter of understanding said nothing about dispute resolution, but it did provide for Dutch law and governing law. And then there was a draft transaction agreement, the main agreement the letter of understanding was aiming at, which was not signed, but the transaction agreement provided for a clause that all disputes arising out or in connection with the transaction agreement shall be referred and finally and exclusively settled under the rules of the NCC. And any party may apply to the Amsterdam District Court following proceedings in English, NCC, for preliminary injunctive relief. So we have a letter of understanding which does not deal with the competent court, but was signed. And we have the transaction with Eddie signing, which was not signed, but which had the NCC clause as the competent forum. Now, the NCC ruled as a starting point that a clause for the court, in this case the NCC clause, is separate from the main agreement in which it is concluded. And that means that a separate analysis must be made of the issue as to whether parties have an agreement on this clause. And this analysis on the clause is separate from the analysis of the issue as to whether parties have an agreement on the main agreement. So whether or not the transaction agreement, which was not signed, has become effective, that is a completely different issue. We are here only dealing with a clause in the letter of intent. Now, the transaction agreement provided clauses like it must be executed and delivered before become effective. But then again, that does not relate necessarily as to whether a clause for a competent court is valid. And equally, this applies to a clause on agreement. The entire agreement clause means generally that an agreement is only valid if parties have entirely agreed on everything. But that relates to the agreement. Whereas if you're discussing merely whether there is a jurisdiction, that is a separate issue. Now, and taking all circumstances into consideration, and I'm not going to mention all these because then it will take hours, but in the end it was ruled that taking everything into consideration, the letter of understanding, which was signed, and the termination agreement, which was not signed, were so closely connected that parties must have understood in the termination agreement, which was not signed, did apply also to all matters relating to the letter of understanding. Now, this means that therefore you can have a clause in an agreement which has not been signed as being valid, and that is a completely separate issue from whether the agreement as a whole has been agreed or not. Now, this may raise many questions for everybody, and that's maybe the nice part of today. Thank you.
Thank you, Justice Oranje. Maybe now, because we are running out of time, I will jump to the final topic, which is the recognition and enforcement. I would probably start with Justice Anderson, who introduced the topic in his first intervention, and then I would ask Michael also to go through that topic, raising also one of the questions that I can see in the chat room related to the conversion of of judgments into arbitral awards, to use the New York Convention. It's a unique experience, I believe, from the IFC. But I will start with Justice Anderson. You have the floor, sir.
Thank you very much. And as far as recognition and enforcement of foreign judgments are concerned, the basic principle I alluded to earlier applies, and that is to say that our common law jurisdictions in the Caribbean tend to follow the English system, which has been outlaid now for a couple of hundred years. And I think Professor Hartley mentioned that as a rule, we tend to recognize and enforce judgments given in foreign countries in our courts. Now, in the old days, of course, a fresh action had to be brought on those foreign judgments, and it was on the basis of that fresh action brought in the Caribbean that judgment would be enforced. In more recent times, though, we have had the introduction of legislation which allows for these foreign judgments to be registered as if they had been given in the local Caribbean courts, and then those registered judgments are in fact enforced as if they were judgments of our courts. The legislation follows the common law for the most part. It really codifies the common law, and therefore it focuses on two things. One, the question as to whether the foreign court had jurisdiction to adjudicate on the case. And that question of jurisdiction turns on two main things. That is to say, whether the defendant was resident in the foreign country at the time of the litigation, and or whether the litigant had submitted to the jurisdiction of the court. A lot of learning turns on this, a lot of cases on this. Many of these have been collected in a book which I wrote, Caribbean Private International Law, published in 2014. Now, if jurisdiction has been established, then the next question is, well, are there any circumstances that could vitiate, nonetheless, the enforcement of the judgment in the Caribbean? And the main grounds, of course, which were argued was grounds of fraud, for example, or grounds of breach of natural justice in the foreign court, or public policy. Now, public policy is very important because that strand comes from and reflects the learning on the New York Convention on recognition of foreign judgments. And we in the CCJ have used that provision significantly in deciding on the ambit of that public policy exception. I think the issue of the enforcement of foreign judgments also has some challenges in relation to the constitutional notion in our part of the world that our citizens have a right to have their cases decided by an independent and impartial court established by the Caribbean, and that this process should take place within a reasonable time. So that there have been issues that have been raised as to whether recognizing foreign judgments, especially by way of registration, would possibly breach that constitutional requirement. But I just put that on the table for what it is worth. I do think that overall, though, the Convention on Choice of Courts is an excellent initiative. I am not myself sure why there's not more uptake by Caribbean countries. Possibly people are not as familiar with it as they could be. And I do believe that there's an opportunity for HCCH to engage in a more aggressive education and sensitization campaign. I do not know how many Caribbean countries have responded to the questionnaire that you sent out, but I think that with a very modest outlay of resources, perhaps couple of young attorneys coming out of the law schools, if they were charged with trying to elicit the responses, I think that would bear tremendous fruit and at a very, very minimal cost. And therefore, that is something that you may wish to consider. Thank you.
Thank you, Justice Anderson. Indeed, we didn't have much response from the region, but your words are very encouraging, and we'll build on that. Let's wrap this up now. Again, Michael, I would give you the floor. I have then a quick question to Justice Orania and Justice Schaller, but let's talk about recognition and enforcement, mostly from the exporting perspective, which often is overlooked. Share with us a little bit this MOU experience, and also if you could touch upon the issue of converting judgments into arbitral awards. We have that question from the chat, and I would like to address that briefly.
Thank you very much. I wonder if I may apologize in advance. After I make this presentation, if you don't mind, I will withdraw because I am due actually to be in another conference call, which starts at 11. So after I finish my presentation, I will retire quietly, and apologies to my colleagues for not staying to hear their presentations as well. Okay, let me deal with this as a sort of stepped exercise. Think of the DIFC courts as a virgin court created out of nothing to be a common law court in a civil law country, an English-speaking, English law reliant territory, if you like, in a civil law universe. How do you get recognition of this new creation? Well, first of all, the national legislation within the UAE declared us to be part of the UAE national courts. So immediately our judgments would be recognized not only in Dubai, but in the rest of the UAE. So you needed legislation specifically for that. But with that, immediately, we had a particular advantage in recognition of our judgments outside of the UAE, because the UAE actually has signed quite a number of treaties with other countries on mutual recognition of judgments. Now, there is an organization called the Gulf Cooperation Council, the GCC, which is made up of 6 countries in the Gulf. And there is quite a tight treaty on mutual recognition of judgments between these 6 countries. So that included UAE, which also included our judgments. So automatically, our judgments could carry through the 6 countries of the GCC. There is also a wider treaty for mutual recognition of judgments within what is called the MENA region, Middle East, North Africa. So it covers not only the GCC, but the North African Arab nations. Now, the Riyadh Convention has a wider adherence, but the language is a bit looser. So there's about 20-something countries which have signed up for the Riyadh Convention, but the language of enforcement is a bit softer, and the statistics on actual enforcement not easily available outside of, if you don't speak Arabic. So we wanted to establish recognition of our judgments in the more important countries to Dubai. So we kind of took a list of what were Dubai's top 10 trading partners. And then we went around trying to seek recognition, not by treaties, because that's beyond our remit, but by court-to-court protocols. And we were lucky enough to persuade the Commercial Court of England and Wales to be our first partner in signing not a memorandum of understanding, because memorandum of understanding, albeit it may not be binding, requires certain obligations of good faith between different parties to that MOU, whether it's by governments or by organizations. Whereas the memorandum of guidance was meant to be statements of law given by the relevant court of the land. So what happened was that we drew up a set of principles declaring what were the principles for enforcement of foreign judgments in England and Wales. And then we had a matching column for what were the requirements for registration of English and Welsh judgments in the IFC courts. And of course, the two were parallel and very, very similar. So that was our first template. With that, we were able to go to other countries. We signed up with 2 states. One state, New South Wales, the most important state, and the Federal Court of Australia. And then with that, we signed a great deal of other memorandum of guidance, not only with common law countries, which were quite easy, but also with civil law countries. And it's interesting, I could discuss each experience with a civil law country, how easy and difficult it was. So we ended up signing about 12 of these MOGs. By that time, this particular protocol became of interest to other people who have had an interest in this kind of reciprocity on a bilateral basis between independent countries, especially of different legal traditions. So this was encapsulated in the new organization that was created, I think in 2016 or thereabouts, called the Standing International Forum of Commercial Courts, otherwise known as CIFOC. And one of the first things that CIFOC had on its agenda was to take our protocol and say, this is a good idea. Let's try and do it on a multilateral basis now. So the first project that CIFOC undertook was to get all of the member states and says, each one of you, please submit to the Secretariat of CIFOC a memorandum on how to enforce foreign judgments in your country. And so over 2 or 3 years, each country submitted their various memorandum describing the process in their country. So this is a collection of information, which becomes like a kind of encyclopedia. It's almost like a Wikipedia if you want, because you can now go to to the CFOC website, and you will see the draft collected memoranda from all the CFOC countries, which is still being revised, improved, and eventually will become a finalized document, which will be of guidance to, well, all commercial parties for the different experiences in different countries. But you can see that this is a long, not really painful, but a long and incremental road, if you like, to universal recognition of foreign judgment, which is the end objective. And so, of course, it is so much easier just to jump onto the Hague Convention, isn't it?
Both Hague Conventions, actually. Both the choice of court and the judgments convention.
Exactly. So let me then finish very quickly with this conversion of judgments into courts. With apologies, that's just a fake headline that I created to get people's attention. It is not actually a protocol for converting a judgment into an award. It was just an attention grabber. And then you go into the detail, which is actually quite painful. But basically, the principle is this. People get judgments. Judgments, by definition, unless they all sign up for the Hague Convention, are less portable throughout different countries for enforcement purposes than the New York Convention. So how do you get the best of both worlds? So what me and some other advisors worked on was a protocol whereby we created a system where our court would recognize a second step to enable a judgment to be the foundation for an arbitration. And then the arbitration goes for a hearing and you end up with an award. And the award must be of a separate cause of action than the original cause of action leading to the judgment. That is the key legal tool that you use. So we had to create a new dispute, and the new dispute would be defined as a dispute about enforcement and not about liability. So the premise is no more arguments about liability. That dispute is over and done with. You've gone through the court process. You've got a judgment from anywhere in the world. And if you happen then to have signed up for an arbitration agreement to say that after judgment has been delivered, if there is a dispute between the parties about enforcement of that judgment, then you go to arbitration. Here's a model clause. You can use the DIFC Arbitration Center or any other center that you want. You can do it yourself any way you want, but the concept will be recognized by the DIFC courts. That's basically what it is. I mean, that's it in so many words.
Thank you, Michael, very much. It's actually a brilliant legal fiction.
By the way, it's an asymmetric clause. So Professor Hart will be interested in. I did a lot of research on this. This is quite interesting. I think we are reasonably satisfied that for arbitration awards, a unilateral or asymmetrical arbitration clause is enforceable under common law. There is a Court of Appeal judgment from Singapore relying on English and Commonwealth authorities for that proposition. We then checked it out with civil law countries. There was an interesting contribution on the French position that such a clause might be considered a potestative condition. Pardon me if I have not quite the pronunciation correct. Of course, I'm anglicizing it. But apparently there is now an Apple case which says no, this type of clause, this asymmetrical clause, is probably not a potestative condition. So that seems to be a trend in France, subject to what my French colleagues will have to say. I've had a letter after I gave this lecture from a German lawyer. He said, I think this will work. A asymmetrical arbitration clause will work in Germany. So, you have to collect from each individual civil law country to see whether or not it will. But that is one of the foundations which needs to be tested out. I think I'm satisfied that it will be enforceable in common law countries. I can't speak for all civil law countries.
Thank you very much, Michael.
And good evening to everyone.
Thank you for making the time. And I apologize to everyone to overrun the time, but I would still challenge Madam Scheller and Justice Oranian to one quick question. are your judgments facing difficulties when being exported? In recognition, when seeking recognition and enforcement outside the Netherlands and outside Paris? Have you faced any issue with it?
I'm not sure that I have ever had to even think about it because I'm not the judge in charge of enforcing abroad.
Okay.
If you understand,
I'm not aware of any case. I just asked if you were aware of any of your own judgments.
Well, I'm pretty confident that there is no problem within the EU.
Yeah, for sure.
And I have not done any research with respect to the enforcement and recognition of our decisions abroad, outside of bilateral treaties that we have with many countries, and also with the Lugano Convention. And so I don't have an answer for you today.
Thank you very much. In any case, Justice Oranje, you want to add something? 30 seconds. You can we unmute Justice Oranje, please?
Oh, yeah, you have to be every time. We are maybe a bit, as judges here, like Werner von Braun, who in the middle of the last century built rather destructive military rockets and said, as long as they go up, we don't care where they come down. So we don't really look what happens with our judgments. But I get the impression that we do not really have very much difficulties at the moment. But we easily tie into a discussion with arbitration, of course, seen as one of the advantages of arbitration at the start, that under the New York Convention, you can easily have, but I think in practical terms, many countries are prepared to accept Dutch judgments. And that's because we and other countries in Europe are seen as civilized countries. Thank you.
Thank you. And in any case, I would say that you gave me a nice example. With the choice of court, we'll always know, or we'll have more predictability when it's coming down. So we will use that from now on. I will wrap it up now.